In order for an individual to be approached by a police officer, one of several things must occur. If there's a motor vehicle accident, a police officer has an obligation to go to that scene and try to assist. So we're not talking about a probable cause for the police officer to arrive on that scene, but we are talking about probable cause in order to make an arrest. What is it that the police officer, what type of information did they ascertain when they arrived on the scene? Was the individual hurt? What led them to believe that they were intoxicated? Did they smell of alcohol? Did they have bloodshot and watery eyes? Perhaps they had bloodshot and watery eyes because an airbag deployed. Were they staggering or slurred speech? Perhaps they were staggering at slurred speech because they were just in an accident. So the issue of probable cause for the police officer to arrive might not be at issue, but probable cause may be at an issue for the arrest of that individual. Furthermore, there's probable cause issues when someone is pulled over. So if a police officer states that someone was pulled over because they were weaving in and out of the lines, or they'd had some other traffic infraction, that can be challenged at a pretrial hearing to determine whether or not a judge believes there was probable cause to pull somebody over. So those types of defenses are ripe in any DWI case that has them. Furthermore, very often in the city of New York, there are checkpoints. A checkpoint is where a police department sets up a roadblock. And those roadblocks or checkpoints are inherently unconstitutional unless they can be established that they are set up for a legitimate reason and were conducted in a legitimate way. And I've had cases where we've challenged checkpoints and had those checkpoints suppressed because they were not constitutional.